Welcome to Bad Law, Worse Facts. My name is Michael Takla. Today I have on Sherra Gilbert. She's a mediator in Houston, Texas, and she kills it. She has mediated quite a few cases for me and has put me in my place a lot of times. But you really do a really good job. But, tell the viewers a little bit about your background. You weren't always a mediator.
No, I began my mediation practice in 2019. It seems like a long time ago because the pandemic makes things seem so much more, just longer. But before that, I was in-house counsel for an insurance company. I won't name the one, but if you know me, if you had cases with me in the past, then you'll know which one it was. Staff counsel for a long time, and then I moved to what I would call a boutique defense firm, and I did more high-end commercial litigation, 18-wheeler defense, business litigation, premises defense, mostly commercial litigation on a much grander scheme. My primary background was defense before I became a mediator, but I did do plaintiff's work actually before I did the defense side. Something that I did before I even started in the defense world was I did workers' comp, which is a very high volume practice. Yes, and it's very convoluted, but it's helped me a lot in my practice today because nobody understands workers' comp, I feel. So, it's kind of like that area where the liens can get real tricky and it makes the case really unsettlable. But yeah, so my background, I did have a lot of workers' comp experience and some PI experience, but the run-of-the-mill car accident, slip and fall, dog bite, from a solo practitioner standpoint, I wasn't doing anything super extensive. But I did try a lot of workers' comp cases. Rather, they are bench trials,
Yeah.
And so that's significantly different from a jury trial. And even before I did workers' comp and PI, the limited PI on the plaintiff side, I did immigration. So I really thought that I was going to be an immigration attorney. I grew up in Laredo, Texas. We moved there when I was 6, and I began speaking Spanish at a young age. I learned it in, just immersion from my friends, but also they taught it in school. In high school, I had full-blown Spanish classes, and in college, I took all of the CLEP, the exams to CLEP out of having to take college courses in Spanish. And so I got really lucky with knowing Spanish. I clerked for an immigration attorney in law school. I thought this was my calling. This is my destiny. I'm a Caucasian female who speaks Spanish. I'm going to save people. And I tried a bunch of bench trials to the immigration judges and wrote a bunch of they call them BIA appeals, Board of Immigration Appeals. And I kept getting really, really bummed out that my clients, were losing, and I don't like to lose. You're an attorney, the last thing you want to do is lose anything for that matter. It was a process. I was hoping that, amnesty would come about and I'd hang up a shingle and make tons of money, right?
Yeah.
And so, unfortunately, the immigration reform never really transpired. I got tired of trying bench trials. I moved my way into, at a place where I could learn a little bit more about the civil side of things. Got to try some workers' comp bench trials. And then I said, I want to be a jury trial attorney, right? I want to try cases in front of a jury. There's an art of trying cases in front of a jury. But nobody would hire me. Nobody would hire me because I had no experience. And this was back in the day when you had to have experience to get jobs to try cases, right? They didn't just hire you out of law school and say, hey, you don't have any trial experience, but guess what? We trust you, so just go try this case. It wasn't like that. I got out of law school in the middle of a recession where you were begging people to hire you.
Yeah.
So it's changed dramatically since I first started practicing law and got into the civil side. But I got this job at this insurance company in their staff counsel office. I was the youngest lawyer in this office that they had ever hired. The attorneys were way more senior than I was, 7 to 10 years in practice, had tried numerous jury trials, and I was hungry. I wanted to try cases. I said, give me your crappy cases. I will take them to trial. I will happily go and try these cases because this was just something that I wanted to do. I was a hungry, young green attorney, and I took anything from JP court cases in all of the Harris County and surrounding areas and tried those cases and also took any case in basically all over the state of Texas. I traveled to Orange, I traveled to Jefferson County, I traveled to Victoria, I'd go to Columbus. I've been to the majority of the courthouses here in the state of Texas, but I was fortunate enough to get that opportunity. My first year trying cases for an insurance company, I tried between 12 and 14 cases. We used to try that many cases back in the day, and then it just kind of snowballed where I was trying that amount of cases every single year. I loved it. It was an adrenaline rush, and you got so comfortable in the courtroom. You got comfortable with your voir dire. You got comfortable talking to people. You got really good at objecting and knowing your evidence and getting to know the judges. And I'm so fortunate that I got that experience, because poor young lawyers and junior lawyers don't have that these days. No. They can't just go down to the courthouse and try a case and hone their craft. And I got really lucky, and I tried a ton of, I just kept my teeth trying car accident cases, slip and falls, and dog bites until I couldn't try them anymore. I got really burnt out. But it was fun. It was fun. And if you knew me, when I had more of my practice trying cases, we would try the cases that needed to be tried, and we would settle the cases that needed to be settled. And sometimes the insurance company would tell me, "Hey, Sherra, you know what? Let's just go see what a jury wants to do on this case." And they would send me to try cases over $1,000, and I'd rack my brain around it. But you know what? I'd have to drive my little car somewhere and go try a case and either get my butt whooped or win, and come back to like tons of emails and reports and do it all over again. So that's just kind of the way it was.
That's crazy to me that they would have you try a case over like $1,000. It's going to cost them more money to try that, like way more money to try that case for that day that it's going to take. But I guess,
well, we were salary employees, and the landscape of the legal world has changed, and I'll get into that.
Yeah.
But yeah, I mean, we were salary employees, and they just figured, let's just see what a jury's going to do, right? Or this is a test. Let's test this particular kind of case and see what a jury's going to do in this jurisdiction. And at the end of the day, it wasn't my money, right? So I would try this case. And back then we used to have blue sheets, which I don't know if those exist anymore, but you get a verdict and then you'd report it, and then they'd send you like this pamphlet with the verdict and what the jury did, and I'd collect these. It was just like my trophy case in my office. But it was really cool, to see your name in writing, and good or bad, the verdict result, I was making a name for myself. And I liked doing that because I knew in the end of the day, there was something bigger for me later. Yeah. I didn't know what it was then, but I knew that if I worked hard, if I tried cases, if I was a fair lawyer, I wasn't a snake in the grass.
Yeah.
And at the end of the day, if I told you, hey, I only have this amount of money on this case, can you make it work? Or if you told me, no, Sherra, I can't, we just got to go try it, we'd go try it, and we'd shake hands at the end of the trial, right? And so I really prided myself on being an ethical lawyer who didn't do dirty stuff and tried cases fairly with my opposing counsels and worked with them. And that's how I developed relationships with other lawyers.
Yeah. So 2019, did anything in particular happen that you said, you know what, I think I'm going to, try to be a mediator? I mean, really just work from both sides, or is it, just something you were looking forward to the whole time? By the way, I'm also super shocked that you did immigration. I had no clue you did that, but, we'll get into that later.
Something that happened in 2018 was I sat for the board certification exam. So I took all of my trials and said, you know what can I do with this, right? Yeah. Like, how do I make myself better? And I sat for the board certification exam, and I got board certified, and I thought, okay, now, that's an accolade that I really wanted. That was a personal goal, and I decided for myself, I really want to do this. Yeah. Want to challenge myself. By the way, it's one of the hardest exams I've ever taken in my entire life.
Okay, is it harder than the bar?
Yeah, harder because there's no outline. It's just wretched. But I'm so happy I did it. So happy I have that under my belt. And then I went back to my employer and said, hey, I'm board certified. What do I do, right? Like, am I going to move up in the ladder? And unfortunately in corporate America, there's all kinds of levels and hierarchy and red tape. Right. And you don't really fit in a box. And I remember I was up for a position. I didn't get it. but I tried more cases than this person. I settled more cases than this person. I was board certified. And it was just kind of a blow to me. And no disrespect to them making that decision. They had to do what they had to do. And that person was equally as talented or even more talented and certainly more senior. But I just didn't like that. It didn't sit well with me. I felt like I had worked my butt off. I really had done the things that I needed to do to prove to this particular organization that I was worth, a bigger investment, and that didn't pay off. I actually interviewed for a much more prestigious insurance company, got that job, and then a headhunter contacted me and said, "Oh no, there's a firm that would like to talk to you about, maybe being a part." At that time, they called it a member. It's not really a partner, but it's profit sharing, certainly. And I said, "Okay, well, this might be the thing that I'm interested in." And I said, whoa. I said, "I'm interested in also being a mediator. Do you think I can do that under your umbrella of, this membership?" And we worked a deal, and I then became certified as a mediator, and I started to do some mediations under that particular firm. And it was kind of explosive. It just kind of took off, and I realized that this was my calling.
Yeah.
And more so because when you're in the defense land and you're trying so many cases and you've got a heavy docket, it's almost like you're a business owner. You got to figure out, okay, how do I get rid of this stuff that doesn't need on my plate, right? And I would work deals with people. I'd broker deals like, "Hey, I'll get you on this case. Look, you got some problems on this case, but I'll get you on the next one." We would work little deals together. I figured being a mediator is really being a broker. I was always the middle person between the insurance company and the plaintiff attorney, right? It was like, look, it's us against them.
Yeah.
So I would always work deals with people, and I'd say, let's get this worked out. The first thing I do is I pick up the phone and I call a lawyer when I got a lawsuit and said, why do I have this? What did we do wrong to evaluate this case? Or what have you done wrong to not get paid on it? Help me, help you, help me, right?
Yeah.
So I guess I realized that I could take that and monetize it. And I was like, yeah, let's do it, right?
So you're like, "Hey, look, I'm already doing this. How do I just make it my thing that I do all the time?"
Right. How do I get paid for doing what I already do, right? Like, I feel like somebody's making money off of me. It might as well be me, So that's kind of how that transpired. Now, there's a little bit more finesse to that, but the short of the long is that's really how that happened.
Yeah, I mean, obviously, you have a very good understanding of what goes into the reports because you used to have to do them, how adjusters kind of evaluate cases. Definitely more than, for example, someone like me who's never done defense side. I've only done plaintiff work, right? So, I assume something's great for trial and it may help their report, but I don't always know that 1 and 2 always stick together. You are able to know that, yes, that's right, or that's a worthless comment, Mike, right? Like, let's move on here. But what I really asked you to come on here to talk about is really kind of like, what, from a plaintiff attorney's perspective, can we be doing that when we go to mediation, you're able to say, okay, he's got all his ducks in a row and he can sell this case?
Well, there's a lot, and it's a really, really large question.
It's a very big question, I know.
There's a lot of things that you should be doing. You should, one, be prepared before you go to mediation. You should have all the ducks in a row. I like to think that I'm one of those mediators that I get to the point pretty quick in mediation. Yeah. There's no kumbaya. I mean, there's an intro speech to your client who needs to hear that. But for the most part, if you know me and you've mediated with me, I ask you probably the same 5 questions. If I haven't figured them out on my own, then I'm going to be asking you those things, right? Yeah. But I think most importantly, the things that you need to do before you get there is you need to have a clear understanding about what your case is worth, right?
Yeah.
Not only from your perspective, but from your client's perspective, and also what you think the other side thinks your case is worth. Yeah. I usually start when I had my practice on the defense side and even on the plaintiff side. The first thing I'd look at is the jury charge. How am I going to prove or disprove this case? Yeah. And I always think that plaintiff lawyers should be looking at that, because when you come to mediation, if the case doesn't settle, that's the next step, is trial, right? So you're going to be asking for these damages, you're going to be asking for these medicals, you're going to be asking for the jury to make decisions about X, Y, and Z. I hope that you've looked through the jury charge to determine what your case, where you're at in your case, and if you've gotten there before you come to mediation. Because if you haven't, guess what? The other side already knows that, right?
Yeah.
So that's my and I'm not saying you have to look at a jury charge or formulate a jury charge before you come to mediation. That's not what I'm trying to tell you. But what I'm trying to tell you is you should know your case from the inside and out, and you should know the strengths and weaknesses of your case. Because guess what? The defense side is paid solely to do that. They're solely they're paid to do what are the strengths and weaknesses of my case. They have a much easier job than the plaintiff side does. Have a much, as opposed to the plaintiff side who has the burden to prove and has to prove everything. And you got to prove it down to the T. The jury isn't going to give you any leeway, and neither are the defense, right? So preparation is key. Sorry, I didn't interrupt you, but preparation is key, and also knowing your case, knowing your strengths and weaknesses of your case, and knowing exactly why you're asking for what you're asking for when you come to mediation. Because if you don't know that, you're not confident in that, I can't sell that in the other room.
Yeah.
Right.
Yeah. And being real about it too. I think you need to be real about your weaknesses. And at least when I mediate, I feel like the more and more real I am about it, the more and more the mediator understands that I've evaluated the case better. My client understands that I've evaluated the case better. And, if the client has high hopes, I think the mediator hearing me say the weaknesses, understanding them, and being able to be a third party to vocalize that to the client of why that's a big deal is a lot bigger than people think, right? But if I go in and say I have a perfect case and I haven't, for example, like I'm arguing, oh, look at this client's lost wages claim, and I haven't really proved it up, I've got nothing, right? And the mediator can't go back in there and just say, well, they've got this law of wages they haven't proved, and he's so confident about it, it's worthless, right? I mean, that's not going to help anyone.
They're going to hold you to what you have to prove, in a court of law, the admissibility of things. Are you going to testify and before or after taxes? How can you prove that? Are there going to be lost wage statements? Are there going to be documentation to substantiate your claims, right? They're not going to give you any leeway in mediation, and I don't expect them to, because a jury shouldn't either.
Yeah.
Right.
So what are some common pitfalls that you see with plaintiff attorneys that you're just like, man, this needs to be fixed?
Well, a lot of the things that I see that look, there's a lot of great lawyers that come and mediate with me. There's great lawyers all over the state of Texas, and I don't just do Harris County. I do Dallas County. I do Bexar County. I do some of the valleys. I've seen all walks of life. There are great lawyers, and then there's lawyers that disappoint me on the daily, because I'm like, I expect more from you, right? But we'll get you there. We'll get you there. But the pitfalls that I see really and truly are, you should shoot your shot, and that's fabulous, and that's great, but you should not oversell to your client, one, and two, oversell your case, because I think that hurts your case and the credibility of your case. For example, I get a lot of times, sometimes plaintiff attorneys come in and they say, well, I know I can get this at the courthouse. Well, if you're guaranteeing your client a certain amount of money at the courthouse, why are we here? They're not going to listen to anything that I say, because you've now guaranteed them XYZ dollars. Anything that I say, they're not going to listen to, because they already have a set number in mind, because you've told them that, right? And that's why mediation is not going to be effective. I oftentimes tell plaintiff attorneys, it's fine to tell your clients what the policy limits are, but you should never tell them that their case is worth policy limits, because the other side never comes to pay the policy limits on any case. Even on the 30-60 cases, even on the minimum policy cases, or even on the cases where the meds are over the limits, right? So I think that's a big pitfall, is coming in and beating your chest and telling your client your case is worth this, because guess what? A case is only worth what the other side is willing to pay or what the jury is willing to award, neither of which you can guarantee, because you don't know the answer to that, right?
Yeah, that's right. Also, I also feel like if you go into mediation, most likely they don't have policy limits on it. Just a high likelihood there, or else they would have given it to you when you sent it to man, unless you didn't.
And I typically tell them that. I said, I don't think they would have. I don't think they would have paid me to have them tell me to tell you that they're going to tender limits. That's just a complete waste of time. Now, I will toot my horn and tell people that I have gotten people policy limits in mediation. Now, that is actually something that I've done, but that just comes from the point of having to explain to their side why the case is worth policy limits, or if
Right.
a plaintiff attorney coming in and negotiating over policy limits, that may be a situation where we got it done for policy limits. But yeah, I would say guaranteeing your client some results. That's a big no-no. That's a huge pitfall. Not coming in prepared, having all your ducks in a row. If there's a surgical recommendation, I sure hope that you got that to the other side long before we got here, and you didn't just plop it on the mediator's virtual desk, or desk for that matter in person. And now they're sitting here like, I don't have enough money to evaluate this case, and they're also mad at you because you've done this, where we could have actually discussed that, and maybe they could have considered it long before you got here. So some of those things are certainly frustrating, in terms of the pitfalls, but I think that doesn't happen as much, I feel, in my cases, because I educate people if they do that. I say, make sure this doesn't happen again, because that's going to be a problem. And not that I would put you on a do not fly list. I would never do that or tell you that I would. But I certainly would try to educate you away from your client and say, hey, look, for next time, let's make sure we don't do these things, right? So it's an education process. I'm molding you, and you're molding me to some degree.
Yeah, and also, you don't want to look bad in front of your client where, surgical recs usually are not cheap. So to not have that lumped in and to have them to now evaluate it live, it's a
Yeah,
tall
it's
order.
hard. It's a waste of time, and also I've got to reschedule that mediation. I already know my
Yeah.
calendar will be wild, so it just takes time out of everybody's day where we could have been focusing our time and attention on those matters, because you've got them the necessary information to evaluate the claim appropriately, right? So.
Do you feel like that sometimes it's good for a plaintiff attorney to mediate when okay, so there are times where I kind of get a little aggressive. I'll be nice about it, and it's like an all-state case. I think it's worth the policy limits. I absolutely do. Let's just say it's 2 times whatever the policy limit is in meds, and I've got a good client, and they offer me like $2,500. I do send an email out, and I'm like, hey, uh, in choice words, um, can we just waive mediation here? Like, let's go. Let's just get this done. Um, and I have a feeling, a strong suspicion that it has something to do with whatever that attorney did with the reporting. Do you think that there are times that mediation actually work in terms of, you go in there and be like, I don't know what the hell you did with this reporting, but you guys got this wrong. And is it worth someone like me who's that angry to just do it anyway, like mediate anyway? Because I'm telling you right now, like I've got 5 on my docket that I'm like, look, I would rather a jury tell me I'm wrong than this guy.
Right. Well, let's backtrack a little bit. First and foremost, you should always be talking to your client about whether or not mediation is fruitful, right?
Yeah.
Just because you're mad at the insurance company and the other lawyer,
Yeah.
obviously, and I circle back to this a lot. What does your client want to do? Does your client want to go to trial?
Yeah.
Does your client want to settle the case? Now, obviously, $2,500 isn't going to move the needle, right? I mean,
That's right.
a no-brainer answer. But I've had people call me up and say, hey, look, somebody's asking to mediate with you. These are my issues in the case.
Yeah.
I really don't want to mediate. Convince me that it's fruitful. And I convince them why I think mediation's appropriate. And we get the case settled in mediation. And they're really glad that they called me to ask me whether or not they thought it was helpful. But to go back to your question about whether or not defense lawyers write bad reports, I'm going to tell you right now, defense lawyers are busy, especially staff counsel lawyers.
Yeah.
They're basically running around with their hair on fire, right? I mean, that's just how it is. It really is. You've got to be like the multitasking king or queen. It's a lot. It's a lot. The amount of emails that come in, the amount of reports, the amounts of phone calls. Just the day to day is you're like basically drinking from a fire hose. So it's not necessarily that I think that they write bad reports. I just think that they write what they feel is checking the box just sometimes, right?
Yeah.
I'm talking about the voluminous carriers. I'm not talking about your panel counsel who have more, high-end commercial cases. I'm talking about your car wreck cases, your slip and falls, your dog bite, stuff that's just flooding up the docket. And they've got cases between 100 and 150 files, and they're just trying to check the box to get through. So I feel like there's a lot of that going on. There's a lot of turnover going on in these law firms. And what happens is things fall through the crack, right? Somebody was supposed to do a depo summary and they didn't because they've now left, and now so-and-so's taken over the file. So there is some of that going on, and for those reasons, I do think mediation is fruitful. The other thing is that if you go to mediation and it's a court order mediation, and if you go and get a jury trial because a jury verdict and the mediation's not successful, then you can count that as your court cost, right? So let's think about it from a business standpoint, right? Like it's never a bad decision to spend money if it gets you to a place that's closer than you were before, because I think there's always a way to recoup those costs later on. But yeah, I do think defense lawyers write reports that may not be very thorough, and that in turn gets read or interpreted, and it doesn't always have the same effect. I'll tell you what, I had a mediation a couple years ago where a gentleman took the depo of a plaintiff, a young female plaintiff, between the age of, I can't remember her specific age, she was maybe 18 to 21, and she had some pretty bad scars in her lower extremities, couldn't wear a bikini, couldn't wear shorts, was very uncomfortable in her relationship and intimacy. And the lawyer didn't ask anything about that, right? Because he didn't think about it in the deposition. So in terms of disfigurement, in terms of pain and suffering, in terms of mental anguish, you had all of these components that didn't get brought up in the depo because that lawyer just checked the box and didn't ask the right questions. And I realized very early on in the mediation that the other side did not have enough money on the case because they were not accounting for these types of damages. Right. So I took it upon myself to bring the parties together with the permission of the plaintiff attorney and start asking these questions. How did that affect you? Can you tell us about that? The young lady broke down. And it really changed the landscape of the case because we now had components of the case that weren't considered. And the case was much more valuable than it was before they walked in, right?
Yeah, that makes sense. That's his adjuster must have been pissed. His or her adjuster.
I don't think adjusters get mad. If it's up to the adjuster, if the claim is worth paying and it can be supported, that makes their job easier. Guess what? They want to get rid of the file too. They don't want this file lingering around. The longer that the case is on their docket, the longer that the case is with the company, remember, and that however many hands are touching the file, the company's losing business. The organization is losing business because for every dollar they're putting in that, they got to sell how many policies and get how many dollars back, right? It's a business. So you got to look at it from that perspective. The adjuster wants the case resolved too. But if the adjuster doesn't have the information to support your value of the case, because for some reason it wasn't dictated to them in that way, or it wasn't given to them in that light, then they're stuck. And that's where it takes a good mediator to understand that the reasons why we're so far apart is because we're not looking at the same case from the same lens, right?
Yeah. So tell me, have you been noticing any different trends? Since let me ask it differently. Did you notice anything different first from when in 2019 when you became a mediator and started doing it full time? Did you notice anything different just being a mediator, being in the room with two people at this time, as opposed to just dealing with the same thing over and over again?
Yeah, I'll tell you, I noticed a big difference from when I was trying cases from that time period of, 11, 12, 10, 11, 12, all the way up to 19. We had a big shift in our political schematics here in Harris County. We had a big change. We had primarily Republican judges, and I think carriers felt a lot more, you had conservative judges, and they felt more comfortable trying cases and testing the waters, so to speak.
Yeah.
And as a mediator, you come in and say, well, look, they're not even offering you XYZ because they don't think a jury's going to give it to you. They think the judge is going to rule this way on this particular issue. They think that, Harris County is still conservative. So they would try the case because they don't feel that there's a risk, right? Fast forward to 2020, fast forward to present times, we have a much more diverse situation going on. We have female and male judges. We have a lot more Democratic judges. And a lot more judges who are going to give deference, I think, to plaintiff attorneys on particular issues. I'm not saying it's good or bad or it's more just indifferent, but I think it's brought in the mindset of insurance carriers, of defendants, in that, look, if we go to trial, maybe certain things are not going to be admissible. Certain things that we had hoped that a jury might hear, they may not, right? And we got to make decisions about whether or not if we want to, one, try this case, because if we try this case and for some reason evidence that's supposed to come in doesn't come in, now we have to appeal the case, which is even more money, right? So I think there's been a big shift in the political climate because of the jurist, but two, also the makeup of the jury has changed a lot. You used to get people coming down to the courthouse who may be conservative, but now, Harris County is very diverse. We are comprised of all kinds of walks of life. We're getting a lot more people moving from out of state here, a lot of Californians who are very Democratic and very liberal. And that has changed jury verdicts all across the state of Texas. If you look at Dallas County, for example, they're becoming a lot more progressive. And some of the largest jury verdicts I've seen over the course of the last few years have come out of that particular county and also Harris County. So there have been a lot of things that have changed. You had the Great Resignation. You had COVID. And I recently, and I know we talked about this offline, but I recently served as a consulting mediator where I was, tasked with watching a mock trial, jury trial, presentation of evidence, and the jury receiving, the arguments, and just their watching them deliberate, just to hear what they say. There's a significant shift, and this is all post-pandemic, I think, about profits over people. People really have a significant problem with companies and corporate defendants not taking responsibility for their actions, and that has been a trend that I have seen. Not just in jury verdicts, and I know we've seen it, but too, in these discussions, and just day to day, I talking to people get upset. So I've seen a big shift in that, whereas I don't think that really existed. And if it did, it just wasn't so obvious to me or obvious to us, or really hadn't trickled through the judicial system like it has now.
No, I 100% agree with you with how people are discussing. It's weird. Like, I don't want to say people are more empathetic during COVID, because I actually kind of go back and forth on it, because on the one hand, we were kind of a little bit more isolated, and so we were kind of able to judge people on Twitter and Instagram a lot more, right? So I don't know if we're so empathetic, but I've definitely seen a trend where individuals just generally are more about, we need to build a community that's helping people, not corporations. And so, and that may be because during COVID they didn't feel help from corporations, right? And corporations were getting PPP loans, and they're getting $1,200 a month, which is not that, or a $1,200 stipend, which is not that much when you really think about it. I don't know what it is. I'm gonna have to look into it, but I 100% agree with you, and I do think it's affecting jury trials. I think people are more conscious about, for example, safety rules. If a company's not following safety rules, and a plaintiff attorney could hook it to, well, the safety rule would have cost this amount, and they just chose to disregard it so they can make a bottom line. I mean, people are going to hate them. I mean, it is.
People get really upset, very upset. The other thing that I noticed a lot is, and we used to argue this a lot back in my car wreck defense days, gaps in treatment. Gaps in treatment used to be like literally the nail in the coffin.
Yeah.
And I think people people are becoming a little bit more understanding. Life is life, right?
Yeah.
Things don't always fit in the square. So sometimes they fit. They go outside of the boundaries, and if people have gaps in their treatment, it's not an nail in the coffin as to whether or not you were injured, right? And we
Right.
saw a lot of gaps in treatment during COVID, for example, like where people didn't get treatment for 6 months because they were so afraid to go to a hospital, or they were so afraid to go anywhere outside their homes without being in a mask. We had so many up and downs during the pandemic that it definitely affected people's treatment regimens. But I also think for the most part, I think people are understanding that you go to the doctor when you need to go to the doctor, right? Just because you don't go to the doctor every single day, or just because you don't go to the doctor, for example, when you have a flare-up, that's okay. And it's been hard to kind of explain that to insurance carriers, and because they're like, oh, well, they waited 2 weeks to go to go to hospital. And I said, well, they probably waited to see if their pain resolved, right? I mean, I'm one of those people. If I've got a sore back and it hurts when I get out of bed, I'm not just going to rush off to go to a doctor and say, hey, let me rack up a bunch of bills unnecessarily. I might put some icy hot. I might do some yoga. I might foam roll.
Yeah.
But we really, the way that we used to evaluate claims were so regimented. And if you didn't follow this order, you didn't go to the hospital, you weren't transported by ambulance, and you didn't go to the hospital, and you waited more than 4 days after the accident, then you weren't hurt. And I remember arguing this to juries, kind of trying to buy my own bullcrap, so to speak. And I just think that we are more accepting of everybody's different, right? What may work for one person may not work for the other. And I think insurance companies have had to understand that.
Yeah.
But more so, that also goes to witness qualifications and credibility of your plaintiff. If your plaintiff can't articulate the reasons why they had gaps in treatments, the reasons why they chose not to do these things, and why they chose not to follow their doctor's orders, then they have good reason as to not believe them. But if you can sell that, and if you can articulate those things, and if you have an explanation, I think a reasonable, sensible juror makeup of 12 persons can understand that, and I think that they can see past the insurance defense arguments of, well, they should have done this and they should have done this, and they weren't hurt, right? So.
Yeah. Let me ask you this. This is not even anything we actually just we're going to talk about a bit. When it comes to defense experts, I mean, do you think that they generally help the let me put it this way. I feel like a lot of times they do generally help the defense, but I also feel like every defense expert deposition I go to, I just feel like I could turn this guy, or he's going to have to make concessions that are actually going to end up hurting the defendant's case. And if so, do you think it's worthwhile for a plaintiff attorney to take the defense expert's deposition before going to mediation with you on certain cases?
That's a tough question, because I have answers on, and it depends. It's really a case-by-case kind of situation. Me personally, I happen to not be a big fan of experts in my cases unless it's necessary. Because remember, at the end of the day, on the defense side, those are hired guns, right? You're paying that person for their opinion to say these things, right?
Yeah.
Like the only reason, and not the only reason that they're saying that, but the primary reason why they're saying that is because you've paid them, they're retained by you for these opinions. The likelihood of them saying something different than what you want them to say or what you hope them to say is not very high. If you're a smart defense counsel, you're having a conversation with your expert before you even retain them to find out what they're going to say, because the last thing you want is a wild card. But oftentimes I didn't like retaining experts. I always made it feel like we've made the case way more blown up than it needs to be. Now, look, sometimes cases need experts, and at the end of the day, as a lawyer, you can't argue things other than using an expert to do that, right? Like I'm not an orthopedic surgeon, I'm not an accident reconstructionist, I'm not a biomechanic, and you need the experts. But sometimes they get in the way. To answer your question about whether or not they're necessary to be deposed before you go to mediation, probably not, because 9 times out of 10, what they say in the report is pretty much what they're going to emulate in the testimony. And don't forget, when you notice that expert, Stepo, the other side's paying for it. So again, I circle back to the business decision. You want to maximize the most amount of money that you can get through the course of a settlement. And I would always tell lawyers, let us spend our money on trying to get this case resolved. The more you rack up in terms of defense costs, the more you allow them to sink their teeth into and get married to the defense in their case, it's going to be hard for them to now say, well, no, we need to pay on this case, or at least for the mediator to go, this case is worth this. Well, I can't tell you how many times I hear in the mediation, well, they forced us to hire this expert, and now we spent this amount of money, and whoever's making the decisions about money goes, I've spent so much money litigating this case, and I'm sitting here going, gosh, we could have gotten this case settled for probably half of what you've spent in attorney fees, right, and defense costs and experts costs. So to answer your question, no, I don't always think that it's something that you need to do. If it's the kind of thing where you just aren't buying what the expert's selling and you feel like it's going to help your case so that they can see that the expert is wrong or flawed, but that's going to be a case-by-case situation.
Yeah.
You got to look at the whole picture here because like I said, the more money they spend litigating the case and defending the case, the harder it is for me to now reverse that mindset in mediation and go, well, I know you spent all this money and I know these are the defenses in your case, but this is really what the case is worth. And they're like, well, no, because we've done all these things, right? So you've got to think about that from the plaintiff side as well.
Yeah, maybe you should tell them about the sunk cost fallacy as well. But, but I hear you. I mean, look, whenever they put so much money into it, it's going to be a lot harder for them to sell when they're like, how am I supposed to, as a carrier, as an adjuster for a carrier, sell it that I spent X amount and still had to pay Y? It doesn't really add up.
It doesn't. Now, look, I'll tell you right now, sometimes it happens. And it's just because the case has been either misevaluated or they had to check the boxes. They had to do these things. Sometimes one side may be so unreasonable, like the plaintiff, for example, might be so unreasonable that they have no choice but to do these things, because the only way that they can get you down ever so slightly is to do all of these necessary tasks. And oftentimes that's what happens, and that's just part of the litigation process. But you have to see things from all angles. Remember, you're the person that brought the lawsuit. You're the person that's driving this, so to speak. And really and truly, I think you all really are in the driver's seat. The defense side is more of a reactive seat and a trying to be proactive. So you have control over where you want to take the case. And if you're smart enough and you know how this works and you can manage the business in a way that makes sense without selling your client's case for pennies on the dollar, then you've done what you need to do to get where you need to be. But again, it's a case-by-case situation.
Okay, I got one more question for you, and it's actually more of just a personal curiosity. Do you find that the plaintiff attorney who comes in reasonably as opposed to the plaintiff attorney who comes in unreasonably, which one of those does better generally?
I've seen them in both scenarios. I will tell you the plaintiff attorneys who are reasonable, and I say reasonable, like not selling their case for significant undervalue. I mean, people that know what they're doing, are prepared, know the value of the case, have good relationships with the other side. I feel like they always get more in the end because the other side's going to advocate for them. Yeah. It's going to put the defense counsel in a situation where they go, we're being the unreasonable ones. We're the buttholes. They're coming in reasonably. We're not responding to that. We're not reciprocating to that. And we should be thankful that they are taking a reasonable approach on this case. And this case needs to settle because they're being reasonable. We may not be in a situation where we're being reasonable, but it helps me to go into the other room and say, the other thing is, I can say, I can get your case settled for this now. If we don't get this case settled, I can't guarantee you that this person's going to be reasonable going forward. You're going to lose out on an opportunity, and a very valuable opportunity, to get the case settled at a reasonable amount, at a fair amount. But I can't guarantee you that in the future. I'll tell you a quick example of that. I mediated a case last year, and I wrote a mediator's proposal. And I told the other side, I said, if we do not get this case settled for this amount of money through the course of this proposal, I am not going to be able to get this case settled for at or near this amount. This firm has the capital to litigate this case, and they will litigate this case because that's what they do. Yeah. And lo and behold, the case didn't settle because they didn't accept the proposal. My plaintiff side accepted the proposal. 6 months later, they came back. The case settled for twice as much.
Oof.
So that's a learning lesson, right?
Yeah. It's a very expensive learning lesson.
Very expensive learning lesson. But you know what? I think I earned a lot of credibility in that regard.
Yeah,
those particular individuals, and it's all about trust when you're the mediator. Yeah. You have to be able to trust the mediator and that what they're telling you is really, right, is really the gospel. Because if you don't have the trust and you don't have the rapport, you're not going to get anywhere. And that goes for both sides. And so, it was a kind of a situation where I said, I told you so, right? Like if you had listened to me, we would have gotten the case settled. I'd never bring that up, and I would never ever tell anybody who that was or whatnot.
Right.
But these things happen. And when I come to you and I say, they're being reasonable, right now they haven't spent so much money in the case where they've made it unsettleable. Oftentimes that happens.
Yeah.
And I think you can get it done for this. Now you're going to end up paying more right now, but you're going to be ending up paying more in the long run. And if you just don't do it and for some reason it just doesn't work out, it can happen. And I've seen it happen a number of times. Thankfully, not too much on my watch, but I think the parties in that particular case will never forget that particular mediation.
They may also take you serious the second time around. Like, okay, let's do this right now.
Yeah, they're like, can you get a do-over? I'm like, no, sorry, that ship has sailed. But to piggyback on that particular issue, sometimes the parties just make the case unsettleable. And that can happen. I know I talked about litigation costs on the defense side, but it can happen on the plaintiff side too. I mean, if the math doesn't work, if you've spent more money on this case than it needs to be, and the expenses are all over the place because you've gone and blown up the case to where I can't get the case settled, you have made it a situation where the case must be tried. Right. And I can't do much about that. And neither can the other side, right?
Yeah, the math's not mathing, so.
Math is math. As much as I hate math is math. And it's just, I've gotten much better at math now that I've become a mediator. My bracket game is super strong.
You got those middles really quick, like boom. I've noticed that because I'm like, wait, the middle is, hold on, I just need to open up something. I'm like, I'm so bad. When did I get so bad at math?
I hate brackets. And if we're so far apart, I'm like, let's do a bracket. What do you think? What are your thoughts on that? People look at me like, gosh, so quickly. And I was like, well, either that or we're going to be here for, forever. So what do you want to do? Yeah.
So if anyone wants to get in contact with you, how do they do that? What's the best way?
I have an online calendar, and if you've gone on there recently, you might not find a date until September or October. So I don't know if that's good, bad, or indifferent. I like to think it's good, but it's also, I wish I wasn't so backlogged, unfortunately. But yeah, my online calendar is at www.thegilbertlaw.com under mediation calendar, or you can email me at sgilbert@thegilbertlaw.com. So yeah, that's how you get in touch with me. Typically do mediations at 9:30 and 1:30, and if the parties really need to get in, I have some 4:30 spots, and they're a lot quicker than these September and October days.
Because everybody wants to go home, right?
They do make for pretty quick mediations. I know that the carriers don't like them, but they do work a lot for plaintiffs, especially ones who work during the day and don't have time.
Yeah.
They work pretty well, and I do tend to, the trend is get to the point quicker so that we're not here until 8, right?
That's fair. Everybody's kind of tired. They're like, let's just roll with this. It's probably the most prep mediations by at that point because they're like, let's get this in and out.
Exactly, which is good for me because if you can get to the point quicker, that's great. But you usually find out who the problem child is in the first 10 minutes in those mediations. you spend more time, excuse me, if you spend more time in one room, you realize, okay, you're gone. The other side realizes you're gone. They're like, okay, maybe that's where she's doing all of her work. So, yeah.
Sherra, thank you so much for coming on. I really appreciate it. I think this is really good information, especially for any young attorney, but honestly, for any attorney, just hearing how you look at things and what's important. It's really good. And, thinking about some of the cases on my docket, just like, you know, maybe I need to not say, let's waive mediation on it.
Yeah, it's interesting. Over the course of the last couple of years, I've kind of learned how the sausage is made. On one side, more than I knew before, but I learned how the sausage is made on the other side in ways that I didn't think. And obviously, the climate and the jurisdiction.
Yeah.
I mean, there's so many things that go into what a case settles for, what a case is worth, and how people evaluate claims that has changed dramatically over the course of the last 5 years.
Oh, 100%. 100%. All right.
Well,
Thank
thank
you.
you.
Of course. Thank you so much.
All right.